Hello and welcome to our YouTube channel. Now the news in detail. On the 22nd of July, the Karnataka High Court overturned the ruling of the lower courts and quashed the conviction of a 46-year-old man charged under Section 498A of the Indian Penal Code. The court ruled that the complaint against the man was filed by his second wife, which rendered their marriage null and void, and therefore a case can be filed under Section 498A. Notably, Section 498A aims to safeguard married women from abuse by their husband or their spouse family members. Since the marriage was found illegal, the High Court set aside the conviction order passed by the lower court. The single judge bench of Justice H. Rachaiya asserted that the lower court should not have accepted or entertained the charges as the complainant woman was recognized as the man's second wife. On that basis, the alleged offence under Section 498A of IPC was not maintainable. The court said, in other words, the complaint filed by the second wife against the husband and her in-law is not maintainable. The courts below committed errors in applying the principle and also the laws on this aspect. Therefore, interference by this court in exercising the revisional jurisdiction is justified. The case pertains to Kantharaju, who is a resident of Vitavanalli in the Tumakuru district, and his second wife. He had filed a criminal revision petition before the High Court, where the court addressed serious allegation against him. According to the complainant, she was Kantaraju's second wife. They lived together for 5 years and had a son together. However, she suffered from health issues and was paralyzed, which left her incapacitated. She claimed that as her health deteriorated, Kantaraju's behavior towards her changed dramatically. Later on, he began subjecting her to cruelty and mental torture. To come out of the situation, she lodged a complaint against him. Following her complaint and trial proceeding, the Tumkuru trial court found Kantharaju guilty under Section 498A of the IPC. The verdict was pronounced on the 18th of January 2019. This court verdict was later confirmed by the Session Court in October 2019. However, Kantharaju challenged the conviction and filed a revision petition before the Karnataka High Court in the same year. After a thorough examination, the High Court concluded that the second wife does not have an entitlement to file a complaint under Section 498A. As a result of it, the High Court set aside the earlier verdicts of the lower court passed during January and October 2019. According to the High Court verdict, the lower court should have considered the complainant as the second wife, as evidence suggested, unless the prosecution had established that their marriage was legal, and they should have proceeded according to that. The court said the prosecution has to establish that the marriage of the PW1 is legal, or she is legally wedded wife of the petitioner. Unless it is established that she is the legally wedded wife of the petitioner, the courts below ought to have acted upon the evidence of PW1 and of her mother that PW1 was the second wife. The High Court highlighted two Supreme Court rulings relevant to this case, the Sicha Varan Lal Verma case and P. Siva Kumar case. Justice Rachaiya stated that the ratio of these two judgments of the Honorable Supreme Court clearly indicates that if the marriage between the husband and wife ended as null and void, the offence under Section 498A of IPC cannot be sustained. Justice Rachaiya added that since the complainant mother admitted that the complainant was the second wife of the petitioner, the conviction ruling of the lower court is to be set aside. That's the end of the story. If you like the content of our video, please do hit the subscribe button, share it with your families and friends, and do not forget to post a suggestion in the comment section below. Thank you. Have a